starts with jury selection. And so there are themes that we establish in jury selection. And I just wanted to mention a couple of them. For instance, one of the questions that I always ask the venire is there any better way to determine the damages of somebody that's been hurt in any trauma than simply compare their condition before the trauma versus after the trauma? Common sense. Nobody ever has a problem with that. So we establish that theme because we're getting ready in the opening statement to show the before versus the after. Another thing that we talk about is, does everybody understand what a progressive injury is? A progressive injury is one that by nature gets worse over time, because that's a big theme that we're going to talk about in our opening, is that the best this person is ever going to do is in this courtroom today, because they're permanently injured and they're only going to get worse and worse and worse as degeneration sets in. So that's a theme that gets established in jury selection, and everyone agrees with it. And if they don't, then you get them off for cause. So it's a great double whammy. And then the final, there's several different themes, but the final one I wanted to talk about today in the interest of time, and this is a big deal and you're going to see it in the presentation, is that we don't have to prove. One of the things I kind of I play a little game with the venire, and I say, now we have the burden of proof because we're the plaintiff, right? And we have to prove that this trauma, this crash was the cause of all of our injuries, right? Everybody says right. And I say, no, wrong. We do not have. Trick question.
You gave him a trick question, Rick.
Yep, I do. And it's to make a point, which is one would normally think we have the burden to establish that this trauma was the legal cause. We don't. We have the burden to prove it was a legal cause. And I'm going to go through in a little bit in the opening presentation and show you that the law in Florida specifically defines causation in a legal cause and tells you what a legal cause is. It need not be the only cause. So those are the kind of themes that we establish in jury selection. And then right before the next day, because it's usually a full day of jury selection, the next day I stand up and say, now we're going to give you the opening statement, and hopefully you're going to understand. Now I can tell you what the evidence is. And hopefully you're going to understand why we asked you all those questions yesterday. We weren't wasting your time. We weren't being unnecessarily personal. We have to know how you feel about these issues, because that's what this case is about. Let me show you. And then we get into the presentation. We have what we call the rule of four. And I'm almost finished with the preliminary, the foreplay. The rule of four is this. There are 4 ways to present evidence to any jury. The first way is testimony. That's the least effective. Okay. So the next, what's better than testimony? Text. People tend to believe what they read as opposed to what they hear. Well, you don't want to have a full presentation of nothing but text, because it's too boring and you're going to lose them. But text is better than testimony. What's better than text? Photographs or medical illustrations. Always more informative and believable. And what's better than pictures? And again, we all hear about a picture is worth 1,000 words. It is. What's better than a picture? Video. Point being, every portion of your case, when you're presenting it, it's the rule of 4. Try to present it through video. And if you can't present it through video, then through medical illustrations or pictures. And if not, then through text. And if not, then you got to go back to your old standby testimony. Before we get into the I want to finish with this, the entire presentation, we're going to show you some animated slides, populated slides. And what do I mean by that? For the majority of what we're going to see this afternoon, I'm going to show you a PDF static version of, this is a case that Ryan and Addie and I tried last year in Sanford, African-American female client in a very, very conservative, maybe even somewhat redneck jurisdiction venue. And that, that was an issue. So what we do is all of our slides are animated or populated. I don't have time to do that, or you don't have time to do that today and explain the strategy behind it, or we would be here all day. But let me show you some animated slides, understanding that our entire presentation, when we show it in our opening, is animated. So this is how it would come up when I'm talking to the jury. And we show, again, we've a background of a good picture of our client. But, and everything, again, we established the theme of before versus after. I've got a clicker in my hand. And so we click, and this is what comes up. And then we go, you know, we talk about all of the things that she was before. No surgical implants in her neck. Why do we say that? Because guess what's coming? But she didn't have any before. No surgical fusion of her cervical spine. Okay, so we go one by one by one, and to save time, we've went ahead but this is what we show, and every single one of these entries are things that she didn't have before this crash that she does. Well, guess what's going to happen? It's called precursors. The fact that they admitted liability is irrelevant. This is a damage-only case. And if they want to admit liability, Judge, that's fine. But they don't get to get credit for it. They don't get to talk about it. It's no longer an issue. It's just like if we have a TBI and we drop the TBI claim because we're going to make the neck claim. We don't get to talk about the TBI. We drop it.
Out here in California, that might be different because
no, it's not. And I'll tell you how I know.
He practices out here too.
I'm trying a case right now where a driver with 50 million in coverage, he was driving a commercial vehicle. He was a sleep apnea patient. He was on narcotic pain medication for an injury, and he passed out at the wheel and ran over my client. He tried to, you know, we knew all along he was going to, we're trying to get punitive damages to get fault back in. But we knew all along they were going to admit liability, which they did. And we had a hearing in Riverside, California, only for the issue of, are they going to be able to tell the jury they've admitted liability, and the court ruled to keep it out. Because I said, it's opening Pandora's box. And Dan, to your question, what I tell the judge is, look, if you're allowing them to say that they've admitted it, then we're allowed to, when my client goes on the stand, testify that they only admitted it the week before trial, and that they staunchly disputed it for 2 years. Because when they say we've admitted liability, the natural assumption would be that they admitted it all along. And that's just a lie. That's just absolutely a lie. So we do have that experience in California, although not a lot, Mike. I mean, I've only tried the 2 cases there. This is a case where there was pre-existing conditions. Now, if the pre-existing condition did not resolve before the crash that we're here about, that's a whole nother issue. This one actually resolved. Now, remember, each one of these pop-ups that you see, they populate individually. So in 1990s, there was a crash, in 97, in 2007, in 2010. But look at what's on the right. There were no injections to the neck or back. Why is that important? Because she's going to have them. That's what's coming. That's what's upcoming. No nerve burning procedures, MRIs, surgery. These were all temporary conditions. And we are going to show you the records that say what? All pain is resolved. Okay? So either we show that the pre-existing condition had completely gone back to baseline, or we use the common sense. People are afraid to death, Dan, of pre-existing conditions, and oh my God, they're going to point at that. Yeah, so are we. We're going to embrace it. That makes the plaintiff more susceptible to a worse injury from less of a trauma if they're already compromised. So don't run away from the pre-existing condition.